Incline Court to order. The case that we have for pretrial is 239251, estate of Daryl John Bednorts. Can I get announcements of everyone who is in the courtroom? Let's just do it like this because y'all are all going to talk at once. So I see we have, if I say your name, just say here. I have Howard Can.
Yes, Your Honor, but I'm not here for that case.
Okay, great. Thank you. Derek Van Gilder.
Your Honor, I'm present for Tatiana Bednos.
Okay. And then I see we have Austin Bednorts. Yes.
Yes, Your Honor.
Wayne Bednorts.
Here.
Crystal Harris from the DRC. And then I have someone under user, ma'am. I don't know who you are, but I have an idea.
Carolyn Moore.
That's who I thought you were. Okay. And so Mr. Van Gilder, you're here for the executor. Yes.
Yes, Your Honor, I am.
So I know we have some motions and I'm going to take those up, but before we do, I have the DRC here, which is the Dispute Resolution Center, and they do mediations in our cases. And so what I'm going to do is I'm going to put y'all in a breakout room with Crystal here, and she is going to get y'all set up for mediation in this case. Okay.
Thank you, Judge.
All right. So you're going to have to accept the invitation. So it's going to pop up here in a minute when I create the room and assign you to it. Crystal, you're on mute. I don't know if you know how to get off mute. There you go. So you have to accept the invitation, and then if when y'all are done, just come back to this room. If you don't know how to get back to this room, just hang out in the other room, and I'll end up closing that room after a while, and it'll automatically bring you back.
Thank you, Your Honor.
You're welcome. Crystal. Okay, I think I have all of you. See y'all in a minute.
Thank you.
Austin. Yeah. All right, Mr. Khan, what are you here for?
I'm here on the show cause in the Lacey matter. Miss Soul was served with a to appear on a show cause because she hadn't done the inventory, and we did it last night. Now I don't represent Miss Soul, but I was willing to help her, and she finally gave me the list of the things that she took possession of out of her mother's estate.
Oh, hang on. I'm not calling that case yet. I think that's in person,
Okay.
Right, Martha? I think we have a show cause in person this morning.
Yes, for her, but not for me. I'm just trying to help her get through this.
Well, if the case is set on for in person, it's not for particular people. It's the whole case.
Okay.
It means we're not using Zoom. Martha, do you see it? I don't have my docket for that one.
Which case is it, Judge?
Hang on.
30?
This is pretrial conference. There's a hearing.
I think Kathy's on. Kathy might know.
I don't see anything this morning.
I don't either.
We might have one this afternoon.
All right. Well, then I thought I saw that.
I don't think it's this afternoon, Judge. We have
Is it Macy or Lacey?
Lacey.
Lacy.
Yes, ma'am.
Do you have a case number?
2446547.
46547 P, I'm assuming. Hang on one second. All right, does that cause number have like a letter at the end of it?
Yes, G. I'm sorry.
G. Oh, it's G. Give me the cause number again.
24-46547-G.
All right, hang on. It's on one of our calendars, but it's not on the other. So we'll see what's going on. Got it served. Yeah, that's on person.
For Miss Soul, and she should be there. She
Yeah.
said she was going to be there.
Yeah, I'm not out in the courtroom. I'm in chambers.
Yes, ma'am.
Kathy, I know you can hear me, sweet pea. Can you go get the courtroom opened and get a bailiff? So are you saying, Mr. Khan, that you're just trying to be her lawyer just for this hearing?
I'm not trying to be her lawyer at all. I just prepared her inventory based on the information she gave me, and then I'll file it once she signed it. And she did sign it last night with a unsworn declaration. And I tried to file it, but it was rejected, so I have to reformat it to get it accepted. But it was filed last night.
Oh, so you're saying there's paperwork floating around trying to get filed, basically?
Yes, Your Honor, the inventory.
Okay.
And as soon as I got the information from her, I put it in a form. I had her sign it. She emailed it to me. I tried to file it. I have to fix a formatting error in it, and I'm not sure what it is. But we did try to file that last night.
Thank you for letting us know. I'll let them know when we get out there. I'll pass on what you've let me know. Okay, all right. So back on Daryl Bednort's, what day did you guys get set up for mediation?
February 4th, 8:30.
morning.
All right. So, all right. So, I've forgotten your name again, but you're under a user. I know that you had filed some pretrial motions that you wanted ruled on today. So
Your
I
Honor.
saw you have,
May I interrupt for a second, Judge? I have an objection to the hearing notice for anything that we've got going. She sent it 3 days ago. She sent it on the 31st for this hearing. She didn't include the information for the Zoom hearing, which is required under Rules 21. Additionally, you don't count a holiday, which is January 1st, in that 3-day period. So I believe the notice is defective for anything.
okay, that's noted. But I just want to talk briefly. I don't want to get into a huge hearing yet, but I think a lot of this is, one of them was to preserve evidence.
We have no problem with that, Judge.
Okay, hang on, Mr. Gilder.
I'm sorry. Thank you.
What I was going to say is that is generally the law, that you can't get rid of evidence. There's motions that you can file if you find that the other side has gotten rid of evidence. So that's already in the law, that's already illegal, but I'm more than happy to order people not to get rid of evidence because they're not supposed to be doing that anyway. And then you wanted the mediation, which was actually already ordered in my docket control order. And what I did this morning was what I always do when people get to pretrial and they haven't gone to mediation, is I get the DRC to set up mediation. So that was 2 of them. Remind me what the other ones you had were?
Well, the first one was the motion to file the plea and intervention.
Okay, hang on. You and Austin must be at the same house.
Yeah, I can move over to the other room.
Yeah, so either y'all are gonna have to get further away or you're gonna have to disconnect from audio to keep that feedback down.
Yeah, no, we have a different parlor over here.
Okay,
Okay. Originally, when I filed this on February 28th, docket number 1943274 was a motion for leave to file the plea and intervention. And the proposed order is docket number 1943279.
I don't think you need leave to file an intervention. You filed it and it's been set for hearing and trial, so you're good there.
Okay.
What else did you want to have
Motion to compel discovery, I served on April 25th.
Okay, so motions to compel discovery, our court does not do by oral hearing. You have to set that on a submission docket.
Okay.
So we do submission dockets at 8 o'clock on Thursdays and Fridays when the courthouse is open. So you're gonna have to renotice that. What else did you have?
That's basically it, was discovery.
Okay, so just get that discovery set for submission, and Mr. Van Gilder will respond to that in writing, and I'll look at that without an oral hearing. And so that's it for today. We'll put you on a jury trial docket and for the next setting, and hopefully we'll be ready to go when we get there.
Thank you.
What about the motions to remove her as the administrator and put Dwayne and Austin in, or either make her post the bond?
So if you want them to have to post bond, you need to file a motion for that and get a setting.
Yeah, they did that. Dwayne and Austin from the very beginning filed that motion to remove her and substitute.
Okay, so I'm sorry, I'm not being clear. No, I was clear. I'm just talking about the bonds. The bond you file, you can file a motion and have a hearing just like we're doing today, but you have to do the notice that you're setting it for hearing and let Mr. Gilder, you have to send it to Mr. Gilder so he knows to show up. The motions to remove, that's what we're here for. That's what's on the docket, because that's the big issue, the trial.
Yeah,
So
that's what I'm.
all your pleadings for fraud and all that lawsuit and the motions to remove all the big main stuff, that's what you're going to jury trial on.
Right.
Okay.
Exactly.
So that's what you're getting docket control orders on. So you'll get a new docket control order from me putting you on a jury trial docket because you wanted a jury.
No, not on the motion to remove we've been asking for that since February.
Okay, but the motion to remove is based on all this fraud and misconduct that you're alleging that you're suing for, yes?
On mine, but on theirs, it's on the basic failure to timely file an inventory and appraisement, filing a fraudulent inventory and appraisement, failing to file a final accounting, the failure to disclose information.
Okay, so this is an independent, so she doesn't have to file a final accounting unless someone asks for it and I order it.
Yes.
Okay? I see the motion to file an accounting. That is a thing that can be set for hearing as well, but it needs to be set for hearing and noticed.
Yeah, it was set for the day and noticed.
For the accounting?
Yes. Okay.
Mr. Gilder, I think by law you have to provide the accounting once they ask for it. Would you agree?
Under section 405.004, Texas Estate Code.
Hold on, Mr. Bednortz, I'm talking to Mr. Gilder and I can only get one audio stream at a time. So when you're talking, I can't hear what he's saying. Mr. Van Gilder?
Thank you, Judge. Yeah, Derek Van Gilder. We can provide an accounting, but again, the notice for this hearing for all this stuff is improper and defective for several different reasons. So,
but the thing is, you guys should have done this when they asked for it. They shouldn't even have to have a hearing. It's by law. This thing is a 2020 case. The time has passed.
We'll provide it, Your Honor.
Okay, I'm going to sign an order ordering you to give them this accounting. Because they shouldn't have even had to have a hearing. All right, what other things do y'all think that we're supposed to be hearing today?
The removal of the administrator based on the failure to file the final accounting, the self-dealing potential, no inventory and no appraisal filed on the court, as well as obstruction of discovery, because we've had discovery going on since February. And the most recent request was on August 23rd. And then that's when they actually responded and said, give them till September 30th, which they failed to respond at all after that.
All right.
So there's just multiple reasons why I think it would just be better to remove her as the administrator today. And my brother, Dwayne, wants to do a third-party administrator to do the final accounting.
Yeah, just additional information. I've hired an additional attorney to reach out to Tatiana's attorney directly. They haven't got any response. And so they're building up information to provide to you just to replace an executor and bring in a third party just based on no response from that angle as well.
Okay, so when you're asking, here's the inventory that they filed back in 2021. So they have filed an inventory and it was approved by the court.
Okay, yeah, I remember receiving the inventory. I just wasn't sure if it was filed.
Yeah, it's got to be filed. If it's not filed, the court will go after that without anybody complaining. We keep track of that. So I knew we probably had an inventory.
So Your Honor,
Hang on. Quit interrupting me. Only one of us can talk at a time, and I'm trying to address all the issues that he came up. And if y'all keep throwing more and more in, I can't even remember what we're talking about.
Okay, sorry.
And now I've forgotten. Hang on one second. Let me regather my thoughts. Oh, the appraisers, the court didn't order appraisers. So they weren't required to get appraisers. Now, if y'all want appraisers for something or another, let us know. That typically comes with some kind of objection to the inventory that y'all are saying that something wasn't valued appropriately. I'm assuming in the inventory when you saw it. So you would have to file a show cause for complaining about the inventory and detail specifically what it is that you have problems with in the inventory. I haven't seen that in the file yet. And you wanted her removed for just not doing the inventory, not moving the, but the problem is that is all tied into the final trial in this. And if you want a third party administrator, did y'all post to get that?
Not yet.
Okay, check with your lawyer because there's probably some posting that y'all haven't done. I know you served her with the motion to remove, but that's the only thing that I can remember really focusing on in this. I don't see any postings. So you might have some other stuff you need to do to get that right, but the lawyer would certainly know. Now, Ms. Bednorz, what is it that you need?
The inventory and appraisement, of course, I was never served with any of this. The law requires that on inventory and appraisement, you list every asset owned by the decedent when he died.
Okay, but here's the thing. We're not here on a show cause for an inventory. So I'm not going to get into the facts of the inventory. It's been filed. So y'all said it hasn't been filed, but it has been filed and it's been approved. Y'all can still say it's wrong even after it's approved, but you have to file a show cause motion and get a show cause order for me to order them to come and answer for this. And you have to serve that on them too. So there's all kinds of requirements there that haven't been met for us to have a hearing on that this morning.
It's just when I look at the clerk's record, the only access I have is online to your website, and it does not show the inventory and appraisement. There's an unsigned order there to approve it, but I don't see the actual inventory and appraisement online. So maybe it's all, but it just isn't showing up.
I'll check with my clerk on that. Actually, do I have a clerk here right now? In the county clerk's office? Sometimes they're here, sometimes they're not.
Yes, ma'am.
Kira, Charlotte, yeah. Can you look and just see if there's a reason that wouldn't be showing up online? Kathy, can you go in online from our side, not through Odyssey, but like a third-party user would, and see if you can find it? Anyway, we'll fix that if you can. Anything else for this morning on this case?
Yeah, if I can read this Texas Estate Code right here, the 405.004, that details what the executor must do, and they must detail all assets that came in possession, must show all distributions, must list all unpaid claims, must file verified accounting with the clerk.
Sir, I granted your motion. That's an accounting. That's not an inventory.
No, but I'm just saying as the removal, I mean, as well as the unauthorized asset liquidation, these are all grounds for removal.
We're not having a removal hearing this morning.
Oh, that's what I thought. That's what you said. Sorry.
And they don't have to file an accounting in an independent unless I order them to.
Oh, that's just what the code says, even in an independent administration, that they have to file a final accounting.
That's not what the code says. If they want to close, they have to file a final accounting. They're not trying to close.
They can't. So she could just leave the estate open. Yeah.
That's typically what they do, because if you close an estate and then years and years from now, someone finds some piece of property that no one knew about, some other person dies and wills something to Daryl. If the estate's closed, it's almost malpractice. You can't get the stuff. So I have thousands of independent estates that are still open in my court, because if you close it, and I've had people close and then come back and say, oh, we found something. And they're in big trouble at that point because there's no executor or estate to take it. And that's probably why they haven't closed it.
Okay, understood, Your Honor. I thought
That's
closing
very
the.
common practice.
Okay, I wasn't sure of that. Okay, that's understood. Either way, the final accounting, I think Dwayne and I would be happy with that.
Yeah, I'm gonna give an order. I'm gonna give them a month to do it, but I'm gonna sign orders today for them to give you this accounting. Okay?
Thank you, Judge.
Thank you, Your Honor.
All right, good luck with mediation and yeah, I know who's Kathy? I know I signed an order approving the inventory. You might not really realize, Kathy, you're sharing. Okay, so y'all will get a new docket control order putting you for jury trial. You'll get an order for this inventory, go to mediation, and if y'all want a hearing on the inventory, file a motion for show cause, get it served when I sign the order, and if you want a hearing for discovery, you have to put it on the submission docket. I think that covers everything that we have outstanding.
I believe so, Judge.
Okay, and I have the clerk saying it's not the order on the inventory, Charlotte, that she can't see. She can't see the actual inventory itself. Kathy, why don't you email her the inventory? I know we have that. So we'll email you the inventory so you have it. Kathy's saying, okay, so she's going to email you that inventory. That'll be a quick way to take care of that. Okay, so that's it this morning on this case, Mr. Khan. I'm going out in the courtroom now to handle this, and it's in person, so you're not going to be out there with me.
You're muted.
All right. Thank you, Your Honor. I'm leaving now.
Maybe
That's fine, Your Honor.
Yes, ma'am.
Miss,
Okay, thank you. That concludes this docket.